So welcome. I'm Rabbi Micah Streifer. I'm the director of Laasok, and I'm really excited to welcome you back for this third installment of our Social Justice in Our Texts series. Today we'll be learning from Rabbi Cookie Lea Olshein about Jewish perspectives on bodily autonomy and reproductive rights. Before we begin, I want to acknowledge and thank the partner organizations and congregations that have been part of making this program happen. I'm just going to list all of them so that we can make sure to acknowledge all of those organizations who have been part of this program. They are A Wider Bridge, AMMUD, the Jews of Color Torah Academy, the Central Conference of American Rabbis and CCAR Press, Central Synagogue, Congregation B'nai Israel in Little Rock, Arkansas, Congregation Shaarey Tzedek in East Lansing, Michigan, Congregation Shir Chadash of the Hudson Valley, Keshet, the Kirva Institute, the Religious Action Center of Reform Judaism, the Union for Reform Judaism, Temple B'nai Or in Morristown, New Jersey, Temple Judea in Coral Gables, Florida, Temple Sholom in Scotch Plains, New Jersey, Tzedek Box, and Women of Reform Judaism. It's a mighty coalition of Jewish social justice organizations and umbrella organizations and congregations, and we are grateful and proud to be partnering with all of them. I also want to welcome all of you and thank you for being here and being part of this conversation. I want to thank those who made a donation to make this series possible. If you are interested in donating toward the Social Justice in Our Text series, you can just visit the Laasok website, which I'll drop into the chat in a few minutes once everybody has had a chance to introduce themselves. Now, I'd like to call on one of our partners, Michelle Scheinkopf, who's the Vice President of Social Justice for Women of Reform Judaism, to say a few words about the work that they're doing in this area, and then to introduce Rabbi Olshein. Michelle, please.
Thank you, Rabbi. So yes, I am Michelle Scheinkopf, and I am the Vice President of Social Justice for WRJ, Women of Reform Judaism. And WRJ is the women's empowerment arm of the Reform movement. Our work is rooted in three things: sisterhood, spirituality, and social justice. One of our top priorities is reproductive health and rights. And I am especially glad to be here because WRJ is now co-sponsor of this wonderful Social Justice in Our Text series. It's exactly the kind of learning and doing connection we care about. And speaking of action, we're getting ready for the North American-wide WRJ Day of Action on April 12th, 2026. On that day, sisterhoods, women's groups, and individual members across the U.S. And Canada will take on community projects that reflect our shared values. And I will put a link to the Day of Action in the chat in a few moments. So I'm really, really happy to be here representing WRJ, and even happier to introduce our speaker. Rabbi Cookie Lea Olshein was ordained at the HUC JIR in 2008 and now serves as the resident rabbinic scholar at Congregation Ner Tamid in Henderson and Las Vegas. Before becoming a rabbi, she practiced civil litigation for 11 years, and she brings that whole legal background into her passion for exploring where Jewish law meets American law. She also serves as vice president of the CCAR. Please join me in welcoming Rabbi Cookie Lea Olshein.
And as we do so, I just want to lead us in the blessing for study. So for this moment, if you would like, I'd love to invite you to unmute as we join together in this blessing, sanctifying the act of study in which we join together. Baruch
atah Adonai Eloheinu asher kitshanu b'divrei Torah.
Blessed is the Eternal, whose mitzvot, whose commandments bring us holiness, and who commands us to immerse, to engage in words of Torah. Thank you, Michelle, for that introduction, and to WRJ for your partnership, as well as all of our partners. And I'll turn things over to Rabbi Cookie Lea Olshein.
Well, hello, everyone. I am honored to be here and share with you today. I always say that I learn as much from my students as I do from the preparation and teaching. And so I hope that we can make this as participatory as possible. If somebody can give me a thumbs up, if you can see my share on screen. All right. Hopefully it's big enough. What's important to me is to let you know that I usually teach this topic, Jewish perspectives on bodily autonomy and reproductive rights, over the course of 3 1.5-hour sessions. So I'm going to go fast and furious here. I know many of you are familiar with this topic. I am just going to ask how many lawyers are in the room. Just, raise your hand electronically if you are a lawyer in the room. Just like to get a sense. Okay. Sometimes I get a whole room full of lawyers. Not today. And I know there are a couple of other clergy folks here. And I really just want to, if you don't mind dropping in the chat, what's your why for why you're here? That would be great for me, just to be able to look through the Zoom and the chat and just see what your why is. Because everybody has a different why they prioritize Jewish learning. So, community agreements. Whenever I teach, I always say, there's this concept of elu, ve'elu, these and these, and we understand that we might disagree about something. I always talk about taking space and making space, practicing tzimtzum, being the right size for whatever we're doing. This is a brave space, but not necessarily a safe space. So just want to remind everyone of that. And please just have compassion for all viewpoints as we are going here. So you might notice that, this conversation has been around. Well, we think of it, as being around forever, but it really has been around since the time of Torah, about what rights do we have as individuals to our body? What is, what's the bodily autonomy that each of us has the agency to make choices for ourselves, and all throughout Talmud. And so we're going to zoom through as fast as we can some texts on this. I'm going to try to leave some. We're going to set up some perspective. We're going to go through some texts, and then we're going to come back to sort of modern times at the end. All right. So why should we be having this conversation? What's the current landscape in America? I think we just need to name it. For the beginning of this year, 12 states in the United States have banned abortion, and we have them listed here for you. And per the Guttmacher Institute, you can see that different states ban abortion access at different times. So 7 states before 18 weeks, 22 states sometime after 18 weeks. And here's the statement of why I think everybody's here. 24.7% of U.S. women are expected to have an abortion at some time in their lifetime. And 13% of U.S. women are likely to have an abortion by age 25. So let's talk about the concept of forced birth. Forced birth. This is a phrase that you'll hear in the progressive circles talking about reproductive justice, and it just flat out goes against Jewish tradition. So here's NCJW, one of the leaders, National Council of Jewish Women, something from their website called Jews for Abortion Access. I highly recommend that you go there. Maternal death rates are 62% higher in states that ban or restrict abortion, and babies born in banned states were 30% more likely to die within the first 30 days of their lives. So this is our why we need to be talking about this from a justice perspective. We also know from them, Black and American Indian / Alaskan Native women are about 3 times as likely to die in pregnancy, childbirth, or right after giving birth than Caucasian women, even though 84% of pregnancy-related births are preventable. And bans disproportionately impact BIPOC women, Black, Indigenous, people of color women, and others, those struggling to make ends meet, young people, immigrants and migrants, trans men, and some non-binary people. So it's just not an even keel regarding how these laws apply to everyone in our country. So 3 primary concepts we're going to hopefully cover during this 50 minutes together of learning. We're going to talk about Jewish views on contraception. This is something that we don't always talk about in a reproductive justice Jewish conversation, but we're going to spend a couple minutes talking about contraception to help us understand balancing of individuals' rights with the halakha, Jewish law, right? We're going to talk about access to abortion care to help us understand, again, the balancing of an individual rights with Jewish law. And then we're going to talk about some modern applications. So we're going to talk a little bit about the trajectory of American case law and the issue of church and state. the freedom for and from religion as found in the First Amendment. So I wanted us to just frame this conversation with the actual language from the First Amendment. So it says, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And that's why we're talking about this, prohibiting the free exercise of our Jewish faith, or abridging, of course, freedom of speech, the press, the right of the people to peaceably assemble and to petition the government for a redress of grievances. So the language that is our piece today is prohibiting the free exercise of religion. And then we're going to talk just a little bit at the very end about the potential application of Jewish values, perhaps in future cases. So here we are. And again, apologies, I am going so quickly, but please do use the chat if you want to stop me or raise your hand. Okay. So why are we going to study these texts? We are going to go all the way back to the Torah throughout Talmud, as I mentioned. And remember that Talmud was codified, some people say no later than the year 600. So these are concepts that we're talking about no later than 1400 years ago. And I like starting with the Religious Action Center of Reform Judaism. I know there are folks here with us today that are identify across the spectrum, but this is where the RAC starts its conversation about reproductive justice. In Deuteronomy 4:15, it says, "You shall indeed guard your souls." And that this phrase has traditionally been interpreted as commanding us to protect our health. The Reform movement and other movements believe that this commandment extends to reproductive health. Okay, so that's our starting point. So here we are with Jewish views on contraception. So consider the high Jewish value of pikuach nefesh, right? Saving a life. So if you were to rank our values, you'd probably put pikuach nefesh right at the top. And so what about a scenario where unprotected sex could actually harm someone's partner, right? Where one person's actions can actually bring harm to the other person, theoretically within a sacred relationship, of course. So let's look at Genesis 1:28, and we see the verse that says, God told the humans to be fertile and increase, right? Pru urvu, right here in the Hebrew. We're going to fill the earth and master it, rule over the fish and the birds and everything that lives on earth. Well, when we get to the Talmud in Yevamot here, there's an interesting story that I thought most people aren't familiar with. The Gemara. Now, just so you know, this particular version that I've quoted here comes straight off of Sefaria, and the bold is the direct translation of the words in the Talmud, and the unbolded text are the helper words to help us understand. So I'm going to read it in its entirety, but I want you to know that the bolded words are the ones that are actually in the Talmudic text. So we're taught. The Gemara, the commentary, relates that Rabbi Chia's sons, Yehuda and Chizkiah, were twins, but one of them was fully developed after 9 months of pregnancy, and one was fully developed at the beginning of the 7th month. And apparently this can happen where you can have two different developments of fraternal twins. And so it says, and they were born 2 months apart. Yehudit, okay, the rabbi's wife of Rabbi Chia, she had terrible birthing pain from these unusual deliveries, plural. She changed her clothes, this is after giving birth to this unusual set of twins, to prevent her husband, Rabbi Chia, from recognizing her. And she came before the rabbi to ask him a halachic question. She wanted to ask him the legal question. I always find these stories of disguising oneself that we see throughout to be really interesting. I hope that he recognized her, but we're going to find out he didn't. She said, is a woman commanded to be fruitful and multiply? And he said, no, not recognizing his wife. And so she went and drank an infertility potion. Eventually, the matter was revealed. Eventually, they figured out that she was drinking infertility potions in order to prevent her from becoming pregnant. And Rabbi Chia found out what his wife had done. And he said to her, if only you had given birth to one more belly for me. In other words, if only he was saying, but wait, for me, I want you to give birth again. So, but when he was speaking as the law required, he said, no, you're not required to give birth again. So let's take this a little bit deeper, and we're going to hear another rabbi. Rabbi Bevai taught a Baraita, an extra teaching before Rabbi Rav Nachman. He said, three women may engage in relations with a contraceptive resorbent, okay? And it's defined as a soft fabric placed at the entrance to their wombs to prevent conception. It's called a moch, despite the fact that this practice is generally prohibited. And they are as follows. So these are the three categories of women. This is a minor. So a minor can use this fabric called a moch for contraception. A woman who is already pregnant can use a moch. And then a woman who is nursing. And so the Baraita specifies the reason for each exception. The minor can use contraception because they need to prevent her from being pregnant and perhaps dying at her young age. The second category, the pregnant woman, lest she become impregnated a second time and her previous fetus becomes deformed, ready for this, into the shape of a sandal from being squished by the pressure of the second fetus. Okay. And then the third category was a nursing woman, that she can use a moch lest she become pregnant and her milk dries up, in which case she will wean her first child too early, endangering him, and the first baby would die. So I'm quoting our colleague, Rabbi Leah Berkowitz, who has taught extensively on this topic. And she says, the moch was a piece of absorbent cloth inserted into the vagina either before or after intercourse to absorb semen and thus prevent pregnancy. And she compares it to a modern diaphragm, a cervical cap, or even a sponge. And she quotes Rashi and his grandson, Rabbeinu Tam. So this is 1,000 years ago, right, for Rashi. And she says that they disagreed on how broadly this text could be applied. Rashi, 1,000 years ago, argued that only these categories of women were permitted to use contraception, while for anybody outside those three categories, it would be prohibited. But his grandson, Rabbeinu Tam, just a century later, took a more liberal approach, stating that these categories of women must use contraception for their own safety and to ensure the well-being of their families, and that all other women were permitted to use contraception, but not required to do so. So here we are in the conversation, thinking about how a woman did have authority, bodily autonomy, to make decisions regarding her reproductive health. Amazing to think about that. People were already talking about it in detail 1,000 years ago, right? Now, with respect to contraception to men, because it's both and, we have some teachings that apply to men as well with respect to bodily autonomy. So most rabbis agree that the commandment to be fruitful and multiply apply to men according to traditional Judaism, right? So be fruitful and multiply, men. However, most traditional sources do agree that this means not forever and forever and forever having children, but they talk about it being 2 children. And some say you can actually count your grandchildren in that 2. So it could be 1 child and 1 grandchild, and then you would have fulfilled be fruitful and multiply. So here's another piece from Yevamot regarding using withdrawal as a method of contraception. So male contraception, and again, this is codified no later than the year 600 Talmudically, says after a woman gives birth, her husband penetrates inside and spills his semen outside for the entire 24 months, for 2 years, during which time the baby is breastfeeding, so that his wife would not become pregnant, as that would terminate her milk production and the child might die. And then it's given credit back to Rabbi Eliezer, a well-known Talmudic authority. So talk about controlling reproduction. Both women and men have the ability to control their bodies with respect to reproduction. And I find that to be an interesting piece that we don't talk about enough in public spaces. So there it is. There are some contemporary voices also. This was an article from Laura Atkins, how the current birth control policy, and she puts it, tramples Jewish women's religious liberty. Okay. And she admits, she says, it's true that in order to use birth control, many Orthodox married couples are told they must procure a heter, a dispensation from, I should say, I'm going to go ahead and fix it right there, a little typo, from an Orthodox rabbi. And this is because using birth control is seen as delaying the commandment to pru urvu, be fruitful or multiply. She also says it's true in many cases that couples are only given this permission if having a child would cause significant, notice it says financial or emotional distress, and even then only for 6 months at a time. But when it comes to those cases, it is religiously mandated that they follow the rabbi's advice. Keeping couples from being able to do so constitutes a violation of their religious liberties. Okay, so restricting contraception, prohibiting the rabbi's enactment of the law or interpretation of the law might actually cause someone to violate their freedom to practice their religion as they are guaranteed under the United States Constitution. Okay. So another rabbi, Moshe Khan, Orthodox, psychoanalyst, Yeshiva University Stern College for Women, advises couples to avoid having children for at least the first year of marriage for psychological reasons. And he says, so this is, again, a rabbi saying whether or not you should have children, right? There's a lot of potential for harm that could come when couples feel pressured into having children when they don't feel fully ready. He said the commandment is not just about having a baby, he argues, but raising them, caring for them, providing a healthy environment for them where the marriage is stable. Okay, so again, this is more about bodily autonomy. I'm going to keep us going here. So how is personhood? This is making a transition once we decide whether or not we're going to pursue children. And we do have the bodily autonomy, both according to traditional Judaism, and I would dare say according to liberal Judaism as well. So how's personhood actually defined for purposes of pregnancy, marriage, reproductive rights? When we go back to the book of Exodus, where we hear this story that becomes law about two men fighting. One of them pushes a pregnant woman and it results in a miscarriage. This is the most famous reproductive justice text from our tradition. It says, when a miscarriage results but no other damage ensues, the one responsible shall be fined according as the woman's husband may exact, the payment to be based on reckoning, or some say as judges determine. And this is harsh language for many modern ears to hear, but it is purely a civil case. It is not considered to be what we think of as a criminal case requiring someone to pay with their life. Okay, it's a civil case, money damages. What is the value of this potential later human life? It is not the value of a life. And so I went ahead and put in here the piece from Exodus that talks about penalty shall be life for life if other damages ensue. But if it's not considered a life as a fetus, then it's the civil piece, eye for eye, tooth for tooth. And it really is turned into, it's not physical, it is the value of an eye for the value of an eye, the value of a tooth for the value of a tooth. And so the question is, in the Jewish tradition, is one who causes a miscarriage treated as a murderer? And the answer is pretty clear. It is not. So let's look at Mishnah Torah. So pulling out the commentary, pulling out from these rules. And it says, one who strikes a woman and causes her to miscarry, even though it wasn't the person's intent, it says pretty clearly they must pay the value of the fetus to the husband and damage and pain to the woman. And so what does this teach us? Is that it is a purely civil valuation, and it is not considered murder according to Jewish law. So what if the fetus then is harming the gestational carrier? Typical language, we would say, what if the fetus is harming the mother? What's the Jewish legal status of the fetus? When we go back to AMMUD again, which is the same tractate in the Talmud that talks about contraception that we just talked about. And here's a story. It says, Rav Chisda said she immerses and partakes of truma only until 40 days after her husband's death, when there is still no reason for concern, as if she is not pregnant, then she is not pregnant. And if she is pregnant, until 40 days, 40 more days from conception to the fetus. And here's the language, it's merely water. Okay. Now, we all know, according to modern times, we don't think of a fetus as being water, but there's the 40-day delineation of where, of how the fetus is considered. So up until 40 days, it's even lesser status according to Jewish law, okay, than even as a fetus. It says it's not yet considered a living being and therefore does not disqualify its mother from partaking of truma, of the gifts, of the gifts. I'll just leave it at that. Let's talk about this rule, Mishnah Ohalot. Mishnah are sort of the rules that are sucked out of the Torah. Some people say they were codified no later than 0-ish. Some say 200-ish. And here is what Mishnah Ohalot says. If a woman is having trouble giving birth, and this is harsh language to our ears, they cut up the child in her womb and bring it forth limb by limb because her life comes before the life of the fetus. It's very clear. But if the greater part has come out, one may not touch it, for one may not set aside one person's life for that of another. So how is this interpreted? According to Jewish tradition, a woman is actually forbidden from sacrificing her own life for that of the fetus. Forbidden. And if the fetus would cause her life to be threatened, abortion is her only, quote, choice. She literally has no choice. It's required. Okay. So there's, of course, commentary here by Rashi, again, about 1,000 years ago on this. Its head came out. So this concept of the head, when a woman that is experiencing difficulty giving birth and is in mortal danger. Okay. It's taught in the first section of the teaching that the midwife extends her hand and cuts it up and extracts the pieces, as the entire time that it has not gone out into the world, it is not considered a soul. That timing of the first breath. Okay. The timing of the first breath. It's not considered a soul. And so it is possible to kill it, but we don't think of it as actually killing it in order to save the mother. But when the head comes out, we cannot touch it to kill it, as it is like a born person. Okay. We do not push off one soul for the sake of another. And so, we're always parsing throughout the course of history, when does life begin? This teaching says that when that first breath happens, that's when there is another soul, and we don't choose between souls, and whatever is supposed to happen happens. Okay. Here's another piece from Gittin, from Talmud. One of them said, in accordance with whose opinion is this? It's in accordance with the opinion of Rabbi Yehuda Hanassi, who says, with regard to one who emancipates half of his slave, the slave acquires freedom for half of himself. And one of them added an explanation and said, what is the reasoning that Rabbi Yehuda Hanassi gave for this reading? He holds that, or his decision is based on, a fetus is considered as its mother's thigh. The fetus is a part of the mother's body, and it is though the master transferred ownership of one of her limbs to her. Since the maidservant, the woman, is pregnant, the child is considered just to be a part of her, and it is as though he emancipated a portion of her body. Therefore, the mother is not acting as an agent for the child, and this law, this halakha, does not present difficulty for Rabbi Yochanan's opinion. So the most important part taking from this piece is that the fetus is considered just another part of the mother's body. Okay. And the mother has control of what is happening to her body. If there's a danger for her body, then she takes care of the danger to her body. All right. Now, this one again is going to sound harsh, as many of these do. Mishnah Arachin here says if a woman is about to be executed, they don't wait for her until she gives birth. But if she is already on the birth stool, they do wait for her to give birth until for the execution to take place. So there's no priority for saving the fetus. And this keeps coming up over and over and over. The mother's life, or in this case, the mother's execution, that comes first. Let me go into Mishnah Torah, again, another commentary on, here it is, on murderers and the preservation of life. And so as I'm going through these, I hope what you're seeing is this pattern that continues to develop over and over and over again of the mother coming before. And so here is another commentary. It says, this indeed is one of the negative mitzvot, not to take pity on the life of a rodef. So let's talk about what a rodef is. A rodef is a pursuer, and the fetus is actually called a rodef. The fetus is actually called a rodef, a pursuer. Some even think of the rodef as a leech. That sounds pretty harsh, doesn't it, to our modern ears? So the pursuer. And so that's the name of the fetus. Okay, the fetus is called a rodef. And here we're taught, on this basis, our sages ruled that when complications arrive and a pregnant woman cannot give birth, it is permitted to abort the fetus in her womb, whether by knife or with drugs. For the fetus is considered a rodef of its mother. If the head of the fetus emerges, it should not be touched, because one life should not be sacrificed for a mother. We've heard that again. Although the mother may die, this is the nature of the world. Okay? So we see that, yet again, once there's that breath taken, then you have two lives. Micah, did you have your hand raised?
I hope it's okay for me to make a brief comment. It occurred to me as you were reading that, how different that is from, for example, traditional Catholic hospitals, where the decision was never made in the old days. I don't know how it's done now, where the decision was always made that you could not abort even to save the life of the mother, and how different that is from what Judaism is teaching here.
Yeah, so thank you. They have ethics committees based on Catholic teachings for Catholic hospitals. And so when I'm working with pregnant people, I will often ask them, which hospital are you considering for giving birth? Or what space are you considering giving birth in? And we have the conversation about the horrible what if. In some cities, I was working in Austin, Texas, and the better hospitals were the Catholic hospitals. But when I was in conversation with pregnant people, we always had the conversation about the ethical piece, according to Catholic doctrine, of giving birth in a Catholic hospital. And was that, were those the values that fit for you, right? Because they don't agree with Jewish law. So thank you for bringing that up.
And if it's okay, there was a question in the chat.
Mm-hmm.
So Donald asked, is this not saying that the fetus is a rodef only if it's causing complications for the mother? In other words, it's not, the fetus is not always a rodef, right?
Yeah. So the fetus is always a rodef, but that's literally the word that's used for fetus by many people. So the fetus is always a rodef. What we're going to see actually right now is how it's been interpreted if it's not, quote, causing harm to the mother in a physical way. Okay, so emotional pain, we're going to see, counts as harm to a person giving birth. Okay, if is that the question? I think Donald is asking. Only if it causes physical complications, it can also cause emotional complications. That if let's use the horrible example that if a woman is raped and forced to give birth, or in a state that forces birth, according to Jewish law, and we'll come back to this, we have to consider, would that be being forced to give birth? Would that be a violation of her rights as an American woman, according to the United States Constitution, to practice her religion freely, if her religion, as Judaism does, requires her to give, to have access to abortion care if there is significant emotional trauma and distress? So we're going to come to that language in just a couple minutes. So I hope that's helpful with the question as where we are in this presentation. So, okay, so here is, let me say this. Let's go to Shulchan Aruch. So Shulchan Aruch is about 1500s, Northern Israel, Judea. Here is a piece about the obligation of physicians to take care of their patients. So it says, the Torah has granted the physician permission to heal, and it is a religious duty which comes under the rule of saving an endangered life. If the physician withholds treatment, they are regarded as one who sheds blood. Okay, if they are to hold back on treatment that would save a mother's life, for example, then the physician becomes the one who is shedding blood. Keep that in mind as we continue this conversation. If the physician either chooses to not save the mother, or if the physician is not allowed to save the mother, it is as if, according to Jewish law, that they are the one who is shedding blood. Okay, so let's go to some what we think of as modern. So around 1750, German Orthodox responsum. So what are responsa? Responsa are the questions that are sent off. You send a sha'ela, a question off to Jewish scholars, and they give you a responsa. They send their response back. And so this is a German Orthodox response. By the way, I'm just going to say it's Orthodox in the sense that it was very traditional. I mean, Reform Judaism develops in Germany in the early 1800s. So everybody was sort of very traditional, or what we think of as Orthodox in this time. So here's from his response. It says, the questioner asks about an adulterous married woman, one that is pregnant. And this is a good question. It appears to him appropriate to permit her to abort. And even in the case of a legitimate fetus, there is reason to be lenient if there is a great need, as long as the fetus has not begun to emerge, right? We said the emergence of the head. Even if the mother's life, fix my typo here, even if the mother's life is not in jeopardy, but only so as to save her from the woe associated with it that would cause her great pain. Okay, so emotional pain, in addition to physical pain, starts to be talked about in traditional Orthodox settings as a reason that abortion care, access to abortion care, must be given. Okay, so it is not simply physical pain, physical endangerment. It can also be emotional endangerment. Now, do notice, I wrote in here, how would we define his application of save the mother's life? He uses the phrase great pain. So understanding that there's great emotional pain. And imagine, that this is a pregnant woman who has had an affair and becomes pregnant, right? That would cause great emotional pain, perhaps, to the family structure. And so save the mother's life. I can imagine a horrible situation erupting if a woman was forced to give birth to someone else's baby other than her husband's, right? I think we can all imagine that. So let's move into sort of some modern commentary. And this is from the Conservative Movement's Responsa Committee. It's called the Committee on Jewish Law and Standards, and this is from 2021. So here's what the Conservative Movement says. It says, we seek a way to follow our tradition's nuanced views on abortion in a multicultural society, where the principles of different religions must be respected, and those who are pregnant and those who provide healing must have the right to follow their own conscience and religious traditions without restricting the rights of others to follow their conscience and religious traditions. Jewish tradition values life almost above all else and very much encourages having children. However, even when abortion was greatly restricted, if not completely forbidden, in the United States and the Western world, rabbis generally upheld a lenient attitude toward abortion when the mother's life or physical or mental health were at stake. Okay, so this is the Conservative Movement statement. It says, under those circumstances, when it became possible to abort using medication, that became the preferable option because it is generally less dangerous than surgery for the woman at the time of the abortion and with regard to her future ability to procreate. Okay, so the Conservative Movement is saying, throughout time when medication became available, that was generally preferred over surgical abortion. Says that said, Jewish law also permits abortion to be done surgically when the stage of the pregnancy and the mother's health, both physiological and psychological, require that. New medical technologies have developed that offer data about the fetus, and our rabbis permit abortion in cases where a child would be born so ill as to not survive long or would be severely and permanently disabled. So, why is this paragraph important? It brings up the condition of the fetus, right, as a determining factor with respect to particularly how it will impact the mother. So, if the mother knows that their fetus is going to result in immediate death upon birth, if there's going to be some significant disability, then, and the rabbis are acknowledging that that will cause significant harm to the person giving birth, right? And so they say that abortion is allowed. So it's not just if the fetus causes physical harm to the person giving birth, it's also if the fetus has characteristics that will cause emotional harm to the person giving birth. Okay, so it's a both. Here we are now. It says in paragraph D, this quote, recently, certain abortion procedures have become the subject of political polemics. Nonetheless, keeping in mind the principles and guidelines of Jewish law based on the Mishnah, which we actually talked about earlier, we uphold the use of surgical abortion techniques even in the last stages of pregnancy, what are called late-term intact dilation and extraction abortion. And this is the key part. When that is necessary to preserve the mother's life, or health, or her ability to give birth in the future. Now, of course, everyone likes to go to extremes when they're arguing about when does life begin. But in the Jewish context, and here the conservative movement flat out states, when it is necessary to preserve the mother's life, or health, or her ability to give birth in the future, it's really not a question. It's really not a question for, according to Jewish law. All right. Now they get into a little bit of the United States Supreme Court in their 2021 decision. It says, furthermore, as Chief Justice Roberts is quoted as saying, if the issue in American law is no longer viability because of its complications, but rather the ability of the woman to choose whether to have a child or not, how long during the pregnancy should that right apply? So he's asking the viability question, and is there a limit in the choice? The conservative movement says neither viability nor a woman's right to choose is the basis of Jewish law on abortion, although they play a role only indirectly. And they come right out and say what matters in Jewish law is the woman's life and health, both physical and mental. Okay, and that's critical. And the conservative movement is a halachically based movement. And so they are following tradition when they come up with this statement. Okay? So they say it's really not about a right to choose. It's not about viability. It's really about the woman's life and her health, both physical and mental. Okay? So where does Reform Judaism speak up on this? Reform movement has been a leader in affirming a woman's right to choose and reproductive rights in general, all the way back to 1935. And so I'm going to go through these very quickly. Just a little sampling of the Reform movement's policy resolutions. I'm a Reform rabbi, and I'm particularly proud of this. So the Women of Reform Judaism in 1935 had a resolution supporting the lifting of bans on the dissemination of birth control literature. Okay. In 1947, the CCAR, of which I'm heavily involved, followed with a resolution on birth control, and then the Union for Reform Judaism, then the UAHC back in 1950. In 1965, the WRJ passed a resolution concerning Judaism and the family, stating, we appeal for liberalization of abortion laws of various states and urge our United States constituents to work toward this end. And then we have the URJ, 1967, 75, 81, 90. Stating in 1975, the resolution said, in any decision, whether or not to terminate a pregnancy, the individual family or woman must weigh the tradition as she struggles to formulate her own religious and moral criteria to reach her own personal decision. We oppose all constitutional amendments that would abridge or circumscribe this right. And then the CCAR affirmed the right multiple times of a woman or individual family to terminate a pregnancy, and states that the CCR opposes any amendments in legislation. So let's talk about modern American applications. This is where I think a lot of conversation happens in the world. So let's go back to the First Amendment again. Okay, the First Amendment to the United States Constitution. So, separation of church and state issues. Who currently defines when life begins in the United States? And we just heard the conservative movement actually says it doesn't matter, right? That it's not about when life begins. They say it's about what's happening to the mother, her life and her health, both physical and emotional. So it's a different question completely within Jewish context. So here we have Congress shall make no law respecting establishment of religion or, key phrase, prohibiting the free exercise thereof. Okay. So here's a creative exercise I'd like for us to think about a little bit. Who would be the perfect future plaintiff regarding a religious freedom case related to bodily autonomy with respect to reproductive rights? Who would be the perfect future plaintiff regarding a religious freedom case related to bodily autonomy with respect to reproductive rights? So we've just been through this big, very brief, very quick overview, right? Where we've talked about Jewish tradition, all the way back to Torah, all the way back to Talmudic interpretation, all the way back to 1,000 years ago with Rashi and Rabbeinu Tam, his grandson. And we've talked about interpretations with responsa in the middle 1700s. We've talked about current Jewish beliefs from the conservative movement and the reform movement. And so I've got one here in the chat. A female Jewish or female identifying, yes, Jewish rabbi living in Alabama who has children, but difficult pregnancies with complications that could be deadly, preferably Orthodox. Okay. Think about who the perfect plaintiff is. So preferably Orthodox. I'll jump in and say, first of all, I would hate any woman to have to be the perfect plaintiff. Don't want any woman to have to be the perfect plaintiff. So a pregnant person requesting abortion and the state law says no. Yeah. Case appealed to the Supreme Court. God willing, it would move fast enough. We have challenges about how fast justice works, right? So we would want someone who has a sincerely held belief in their religious tradition. That's really important. So someone who would outwardly identify as Orthodox would be an easier, better plaintiff in the eyes of the government, in the eyes of the United States Supreme Court. Someone whose life would be genuinely threatened if they were forced to give birth, right? Someone who has been an outwardly living a traditional Jewish life where there was physical harm coming. That's the perfect plaintiff. Another perfect plaintiff, although a harder one, would be someone who suffered great emotional distress as a result of the pregnancy. God forbid, please hear me say, God forbid these people exist. Someone, and maybe having 2 or 3 or 4 plaintiffs at the same time to go through in various parts of the country. Problem is that pregnancy is only 9 months and justice takes longer. Yes. And it is dealt with within the Roe decision. Let's talk about a couple of things, and we'll get to the Roe decision. And then I want you to just keep this creative exercise in mind, the perfect future plaintiff regarding a religious freedom case. Okay. So I wanted to bring in this case that some of you are familiar with. I'm sorry I didn't put the quote in here. There's a Native American case, I believe it was back in the 80s, where peyote was outlawed, but Native Americans said that peyote should be used for religious purposes. Okay. And the U.S. Supreme Court actually said, yes, Native Americans can use peyote, even though it was outlawed for religious purposes. The challenge to that case was, to whom did the case apply? It only applied to Native Americans. Now, there's this question of equal protection under the law in the 14th Amendment. And so balancing First Amendment freedom of religion rights versus 14th Amendment equal protection rights it's really challenging. So if we were to take the perfect future plaintiff, Jewish, Orthodox, childbearing woman, pregnant, God forbid, struggling with potential physical harm if she were to be forced to give birth, right? Because of this peyote case, there is an argument that some people would make that says, well, so only, ready for this, authentically Jewish living women, maybe there could be a carve-out exception for freedom of religion because of this Native American carve-out for the use of peyote for religious purposes. Does that make sense? However, we also believe in the 14th Amendment, right, to the U.S. Constitution, and there's a fundamental right of privacy. And that's what Roe v. Wade was all about in 1973. It was where the United States Supreme Court found that the 14th Amendment did provide a fundamental right to privacy to protect a pregnant woman's access to abortion care. And she was a woman, the plaintiff was a woman living in Texas, where abortion at that time was only legal if the life of the mother was threatened. And so here is, by the way, the 14th Amendment is fab. You should read the 14th Amendment. But this is just one section of it. No state shall make or enforce any law which abridges the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. And that court found that there was a fundamental right of privacy which should not be allowed to tell a woman what to do, i.e., prevent them from having abortion access to abortion care. Now, in Dobbs, in the 2022 decision, just a few years ago, there was a finding that overturned Roe v. Wade because they said that there was no 14th Amendment federal constitutional protection to a right of privacy, which would allow then each state to govern access to abortion care individually. So I wanted to lift up Nevada a little bit for just a moment. And yes, Jerry, I agree. We do not want the court to determine who is authentically Jewish. No, we do not. That is absolutely true. I want to lift up Nevada because Nevada is doing something right now that can happen in other states. And that is, Nevada is currently in the process of amending the Nevada state constitution. So Dobbs sent it back to the states, for every state to make its own decision. And Nevada's procedure for amending the Nevada state constitution to allow for abortion in the state of Nevada constitutionally, we have a 2-vote requirement. So in 2 even-yeared consecutive elections, we have to have the proposed amendment passed twice. So in 2024, we had the proposed amendment, which I have right here. And it says, all individuals shall have a fundamental right to abortion performed or administered by a qualified healthcare practitioner until fetal viability or when needed to protect the life or health of the pregnant patient without interference from the state or its political subdivisions. Okay. This right, the right established by this section shall not be denied, burdened, or infringed upon unless justified by a compelling state interest that is achieved by the least restrictive means. And then it defines a compelling state interest, which is a standard by which the U.S. Supreme Court and other courts use. And it says an interest which is limited exclusively to the state's interest in protecting, maintaining, or improving the health of an individual, who is seeking abortion care that is consistent with accepted clinical standards of practice. And then it also defines fetal viability. Now, remember, these are not Jewish concepts. Okay, fetal viability is not a Jewish concept that we make decisions based on, according to Jewish law, according to Jewish tradition. But it does define fetal viability as in the professional judgment of the patient's treating healthcare practitioner. There's a significant likelihood of the fetus sustained survival outside the uterus without the application of extraordinary medical measures. Without extraordinary medical measures. Currently in Nevada, it's 24 weeks. Okay. So we have a second vote scheduled in 2026, which I hope will be passing again. We have a almost two-thirds majority from 2024 to be constitutionally protected within the state of Nevada. Okay, so I want to lift that up. Okay. I also, we're getting close to the end of our time. I just want to encourage folks to go and read the Tennessee there's a trans rights case regarding affirming care, which they're very careful in the United States Supreme Court to say it's not based on gender. In this case, it's Scarata, I think it is. And I want to just encourage you to just type in Tennessee trans right case. So it's not a gender-based case, but go back and read that if you're interested. It's just from 2023. Because it gives us more insights about how the U.S. Supreme Court is working right now. And then also, just from a gender perspective, you may have noticed I've really worked hard today to talk about people who give birth as opposed to mothers, although I do use it interchangeably because I'm still working on that kind of language. But Keshet, which is an LGBTQ rights Jewish organization, has a wonderful teaching, and I'm going to go ahead and drop this link in the text. It's a little bit off our topic, but it talks about gender in Judaism and gives some really great sources. So I just dropped that link in the chat. And I'm going to stop now. It's 12:58. I understand we stopped right on the hour. I'm sorry this has been so frontal, but I just crammed 3 1.5-hour sessions into 50 minutes. And I thank you for your interest in this subject and interest in learning with me and Laasok today. And Micah, we got 2 minutes for questions.
That was amazing.
Comments.
I just want to say a huge thank you to Rabbi Olshein for this incredible presentation. You lifted up Keshet at the end there. Keshet is also one of our partners and one of the sponsors of this program, among that list of incredible organizations that I listed at the beginning. So I do just want to say thank you again to all of our partners, the organizations and the congregations, as well as the individuals who both registered and showed up here to participate in this conversation, and those who gave to make it possible. If you'd like to donate to Laasok to support the social justice in our text series, you can do so at the link that I just dropped into the chat there. Our next session of this series is coming up in less than a month, December 8th, with Rabbi Leah Mosher, repairing the world, tikkun olam as a mystical praxis. So a little less legal and a little more mystical for the next time around as we continue this discussion about social justice in Jewish texts. Once again, a huge thank you to Rabbi Cookie Lea Olshein, and I look forward to seeing all of you again in a few weeks. Take care, everyone.
Thanks, everyone.